COLIN CROLY, les presento acá a COLIN CROLY. Él en los últimos 30 años ha asesorado en todas las áreas de seguros, especialmente en Reaseguros, o sea, él tiene mucha práctica, incluyendo redacción de pólizas, resolución de disputas, no solo en Londres, sino a nivel internacional. Por muchos años fue nominado como el abogado del año en seguros y reaseguros por Who is Who Legal and Who's Who for Lawyers of Business. Actualmente es el Secretario General de AIDA, Chairman de AIDA Europa y del Grupo de Trabajo de Reaseguros. Regularmente dicta en la Universidad de Hamburgo y alrededor del mundo. Ha publicado un importante número de artículos académicos sobre reaseguros y es árbitro de áreas en Gran Bretaña y en Europa. Un fuerte aplauso, por favor.
Thank you. Can you hear me? All right, good. I'm speaking in English because my Spanish is extremely limited. I hope to speak fairly slowly, so those of you who I know are more proficient in languages than I am might well be able to listen in English. I have given the translators a rough outline, so that it will help them, but it is always difficult to translate, especially in more technical language, but they've done wonderfully. I also quickly want to thank AIDA Perú for the hospitality in the organization. It's been great to be here in Lima. The only thing two things have amazed my wife and I. Number one is the traffic, needless to say. London doesn't compare. But the second one is we've come to a city where we are told it never rains. It rains continually in England, so that is a fascination to us. Can you still all hear me at the back? Good, all right. Now, there's been a revolution in England with regard to insurance and reinsurance law. It has changed considerably. And this is because the old principle that was supreme, ubere mai fides, utmost good faith, has to a large extent gone. It is worrying in one way, but the aim was by the law commissions of England and Scotland to bring the law more up to where, in practice, it was now, and also what the judges had been leading it towards. So there are three acts. The one deals with consumer insurance, and that was effective in August 2013. The next one deals with commercial insurance, and that was effective August this year. And then there's another little act, which I'll tell you about, called the Enterprise Act. Doesn't sound like insurance, does it? And that is effective next year. It's a strange name, but I'll explain more when I come to it. Now, utmost good faith has been the bedrock of insurance, English insurance law, for a long, long time. And it is the key distinction between insurance and other commercial contracts. It was introduced a general duty of disclosure on the insured or the reinsured. And it was a strict remedy. If you non-disclosed, if you were not in utmost good faith, the contract is avoided from inception, from day one. You have no policy and you get the premium back. No claims are met. It's a fairly strict regime, as you could imagine. This was established, I'm trying to work out my mathematics, 250 years ago in a famous case in 1766. That is 250 years ago, I think, yes. It's called Carter against Burme, and it was Lord Mansfield, one of the most famous jurists in England, who established this principle. And it all involved disclosure regarding the insurance of a fort in Sumatra in Indonesia. And that is where the tentacles of insurance and reinsurance extended already in those days. And he said, and I will quote just very quickly the most important points from it, "The special facts upon which the contingent chance is to be computed, i.e. calculated, lie more commonly in the knowledge of the insured alone. The underwriter trusts and proceeds upon confidence that he does not keep back any circumstance in his knowledge to mislead the underwriter. The keeping back of such circumstance is a fraud and therefore the policy is void. It's done. Now, the new acts succeed a very old act of 1906, the Marine Insurance Act, which codified the law to that time. Now, it seems as though when an act gets old in many jurisdictions, the academics start and then the lawyers and others join in to change it. And that's what happened. And now it has been changed over 100 years later. And they are probably the most significant changes to insurance law in that whole period. Now, the Consumer Insurance Act, which I will deal with very briefly because I said I will concentrate on the commercial insurance, it's a mandatory regime, but it's based largely on the ombudsman, the financial ombudsman's guidelines that are already there, and guidelines which the Association of British Insurers have complied with for many years. So when I say revolution, on the consumer side, it probably isn't such a revolution because it's stating what already exists. There is no duty of disclosure. It's merely a duty to take reasonable care not to misrepresent any information. And if the consumer acts honestly and with reasonable care, then there's no remedy for the insurer. And the standard of reasonable care is that of a reasonable consumer, an objective test. Now, how you work out that standard is going to be interesting. Do you stop someone in the street, but the judge will decide what a reasonable consumer is, I suppose, in the end. It's difficult to have an expert to come along and say what a reasonable consumer is. But it only takes into account the individual circumstances if the insurer was or ought to have been aware of them. But the insurer can avoid a policy still and refuse to pay any claims if the consumer acted deliberately or recklessly, didn't care. If it's careless misrepresentation, then it's the traditional European, continental European, proportionate remedy. It will take into account of what you would have paid had you known about that. And you will get different terms or different premiums, and it will be satisfied on that basis. And this regime you cannot contract out as an insurer, but as I said, it is probably there already, so that's not so revolutionary. But the new business regime is very different. And business is, insurance is that it relates to somebody's trade, business, or profession. Now, there are new rules here for disclosure and misrepresentation. It alters fundamentally, as I said, this duty of good faith. What now has to happen is there has to be a fair presentation of the risk. That is, and the Act gives examples, that if there are special or unusual circumstances relating to the risk, the underwriter, the insurer, must be told. So there's a two-stage test for your pre-contractual negotiations. You have to disclose every material fact that the insured, the person seeking insurance, knows or ought to know, or you have to give sufficient information to the insurer to put that prudent insurer on notice to ask further questions. So that's two. Either you have to tell everything you know or ought to know, or give enough so the insurer now has to ask questions. Now, in English law, the insurer has never really had to ask questions. As Lord Mansfield said, he has to be told everything. So that's a very big change. The insurer can no longer remain passive. He has to be told. But you can't do the trick, which used to happen and could still happen. Brokers were experts at this. It's called data dumping. You bring in the pile of papers like that, and you put it to the underwriter, say at Lloyd's or somewhere, and there's all the information. And the rarely relevant one is in the third last page at the bottom, hoping that the underwriter will never see it. It has to be a fair presentation, not just a piling of papers onto the underwriter. This regime can be contracted out of, unlike the consumer regime. But if you contract out, it has to be worded with transparency and clarity, and you have to explain to the insured what the consequences are. So he has to be fully informed if he agrees to giving up these new rights. This regime also applies to reinsurance. At first it was thought, when the joint commissions in England, because Scottish and English law is different, but they sat together on this. It was first thought that reinsurance would be separate. The old regime would remain. It hasn't. It's gone. Probably more chance it would be contracting out, because you're talking about two big boys or two big girls negotiating a reinsurance contract. They're both experienced insurance and reinsurance companies. So they might contract out of this regime in favor of the old regime, of perhaps more certainty. So then you've got to decide if you have to disclose every material fact which the insured knows or ought to know. What does an insurer know? How is that going to be decided by the courts? Is that a glass of water? You probably heard my voice going. Thank you. You were very clever. You saw that happening. There is a definition in the Act. Thank you so much, Pamela. Excuse me. Better. There is a definition in the Act, and it includes what is known to any individual part of the senior management or those responsible for the insurance in the company. We're dealing with commercial entities now. So what does senior management know, or the people who are responsible for arranging the insurance? And there's an obligation to conduct a reasonable search. But again, we come back to reasonable. What is a reasonable search? That relies on the facts of every case. And when you hear something like that, you know that there will be a judge always deciding that. There have been very few cases around to help so far. The Act has just come in. And the one case in our Supreme Court, which was the old House of Lords, has commented on the context-specific nature of this. They have to look at the facts to decide how you attribute, how you apportion knowledge to someone. So in my notes I wrote to myself, but I'm not a practicing lawyer anymore, unfortunately. I do arbitrations. Many legal cases to come, as you can imagine, as this has to get interpreted by our courts. So that is the new regime. Out with Uberima Fides and utmost good faith, in with a fair presentation. That's basic rule. And you can contract out, and it applies to reinsurance as well. Now, I said this Enterprise Act was the third revolution. The first one wasn't such a revolution, the consumers. Next one for commercial, yes, a revolution. This one is a very strange name because it's tacked on by Parliament to another act. And what it does, it brings in damages for late payment of claims. And this images of the United States and punitive damages, multiple damages. You were naughty, you didn't pay on time. My friend from America sitting in the back there knows all about that. So, at first, this recommendation was rejected by Parliament. It was rejected by the commissions. And it was interesting because AIDA Europe had a conference in Copenhagen last year. And our keynote speaker was the foremost insurance judge of our Supreme Court, Lord Mance. And he said here, The Law Commission recommended that damages should be payable upon showing that an insurer had delayed payment beyond a reasonable time. And then Lord Mance then says in a very short sentence, to my mind, Parliament was right to reject this proposal. That was June last year. By 2 months later, Parliament was introducing that. So that wasn't very comfortable for Lord Mance to have not been informed what was to happen. But it just shows you the top legal brain in insurance felt that damages was not the right way forward. His view was, you do it through interest, and if needs be, compound interest, which is not normally awarded. At present, no damages are recoverable, just interest, and it's 1 to 2% above the base rate, which at the moment is very low. Now, the new position is that there's an implied term in all contracts that the insurers must pay the claims within a reasonable time. What is a reasonable time? It's an objective test, and the Act makes it clear it includes time to investigate and assess the claim. So they are trying to be reasonable as well to the insurance company. The penalty is there will be damages awarded, and how will those be calculated? You have to show causation, that you suffer damages. It's not punitive, it's not just out of the air. And you have to show that the loss was caused by the insurers in breach of the implied term of dealing with matters in a reasonable time. And that's got to all be proved by the insured or reinsured. So what is reasonable, again, we come down to? That wonderful word. The judges always know what's reasonable, nobody else does. Depends on circumstances, and also there is a non-exhaustive list of examples in the Act. I'm never a great fan of lists of examples in an Act, because for many you put in, there are many you don't put in that you'll then argue about. And some of those are, to give you a flavor, the type of business. For instance, business interruption loss claims will take a lot longer to deal with. The size and complexity of the claim, a big claim will take longer. If you have to comply with regulatory guidelines and rules, obviously you have to comply with those, it might take longer. And then there are factors outside the insurer's control. Sometimes loss sites are difficult to access. You have to get third-party information and the people are not cooperating. That's another example given by the Act. So what might be the practical consequences of this introduction of the new rules? Possibly pressure to settle difficult claims or to make interim payments might be increased. You don't want to risk damages against you, and we know that's what happens in the States. There's a great fear of to be hit with some sort of punitive or other multiple award, so claims are settled very quickly, sometimes with little justification. Also, you can imagine that that would lead on to companies, insurance and reinsurance companies, having to provide and hold higher reserves and commit more capital. So it is a change for the market. And then issues specifically for the London market. And we've just been hearing now about reinsurance with Sergio, Andrea, and Mr. Fisher talking about the claims control clause. Now, what's going to happen if there's a claims control clause in the reinsurance and the reinsurer exercises his right to that clause? He takes over the claim. Now, can the insurer then argue delay whilst outside its control? If the reinsurer takes his time, what happens to the poor insurer? Does he have to then pay any penalty? And then if the insurer is liable for these damages, will the courts decide that insurer can recover those damages from its reinsurer? That's another very difficult issue in reinsurance. Extra-contractual damages, really. Can you recover them? Does the reinsurance policy cover that? Very interesting issue. And then we have subscription markets in London and also on the continent. Subscription markets, you get a whole lot of people with a leader. Now what happens if the leader is entitled to negotiate a settlement, which is often the case, and the leader takes a lot of time and does something wrong? Can you recover from the leader if you're a follower in the market for the damages, the extra cost? That can, of course, depend upon any agreement, but at the moment there are no agreements dealing with such a matter. And then when you have layered programs in reinsurance, what happens if the underlying layer, the primary layer, is delaying payment unreasonably? And the excess layer can't pay until that's been sorted out, and then their damages awarded. Does that impact upon the reinsurer? And do they have to pay because there's an unreasonable delay? Because they're not paying themselves, but it's not their fault. These are very interesting issues which are going to have to be sorted out in the courts, I believe, in due course. There is a restriction of 1 year for bringing these damages, so it's not your normal limitation period of 6. And you cannot contract out of this in consumer contracts. This will be in every consumer contract, that if you delay in settling that claim of your insured, you will pay damages if causation can be established. But you can in commercial, and there will be very careful drafting to cover this, and it has to be transparent. The insurer or the reinsurer has to be explained fully the circumstances of and the effect of this clause. But you can't do it, it will be ineffective if your behavior in settling the claim is deliberate and reckless. Then you can't contract out. So this is revolutionary in the UK. And so revolutionary that the eminent judge said it wouldn't happen, and it was quite right for Parliament to exclude it, and within 2 months the politicians knew better. Well, politicians always know better, we know that for sure. Now there are 2 other areas that were changed, and then I would have taken up my time. The next one is warranties. Now warranties in English law are very strict. They are more strict than practically any other common law jurisdiction. They've been watered down in the States, they've been watered down in Australia. They're still very strict in Singapore and Hong Kong, for instance. A warranty in England does not have to be causative of the loss. It's different to most regimes, as I said, and the Act has now changes this. Before the Act changed it, once you have breached the warranty, you have no more cover from that date. Not ab initio in the old non-disclosure iberi fides, but from the date you're in breach of the warranty, your cover goes. Claims before that will be paid. And it automatically discharges the insurer from liability on that contract from then onwards. The contract is over. Now, the initial push by the commissions was to change this completely and bring it into line with other systems where the loss, where what causes the loss does not have to in any way go with the warranty, i.e. that if what you breached in the warranty did not affect the loss, then you don't have a breach of warranty in laws in most of the continent, for instance. So what they've brought in, that a breach of a warranty now does not result in automatic and irredeemable discharge of the insurer's liabilities, as was previously the case. They've made it a suspensive condition. It discharges the liability of the insurer only for so long as the breach occurs. From the date the breach occurs, if you put the breach right, you get your policy back. During that period, you will not have a claim paid. So no longer is it no policy from the date of breach, it's suspensive while you are in breach of the warranty. And the insured can still recover if it can show non-compliance could not have increased the risk of the loss which actually occurred in the circumstances, i.e., it was irrelevant to the loss. And there's a famous case called the Norwegian fish farms case, which illustrates this beautifully. It was an insurance and a reinsurance of a salmon farm on the coast of Norway. And the warranty was that there should be a 24-hour watchman at the fish farm, night and day. There was a terrible storm. The nets and the farm were wrecked. The fish all swam away. And the night watchman wasn't there. Breach of the warranty. In English law, no claim, finished. Norwegian law, because it ended up a battle between English and Norwegian law, and then our top court fudged it. Norwegian law said, it made no difference. Was he going to run around and catch the fish? But English law said that doesn't matter. It's a breach. Now, what's changed now is that we would fall in line with what the Norwegians would have said. It's got to be shown that it actually would have affected it. You probably think that's more fair, don't you? But why the marine lobby push so hard to keep warranties is because when ships are on the seas, they don't know what's really happening and where they're going. They have to have a big, big trust in this. And the marine lobby is very, very powerful in the City of London. And they then use this warranty when they can't really establish what's happened. And they said if they couldn't have warranties anymore, it would push up the cost of marine insurance enormously. So they've been met halfway. The other one I want to mention in my last few minutes is fraudulent claims and what remedies there are. Fraudulent claims. The Act states some general principles now, and it has set aside the uncertainty that there was. Before, it was never clear. If you committed fraud in your claim, but your earlier claim wasn't fraudulent, you perhaps got paid that. Or if it was only a little bit of fraud, you could still recover. I always loved that one, a little bit of fraud. I personally don't believe there's a little bit of fraud. There's either fraud or there isn't, especially in an industry like insurance. So they realized that this was a problem, and this was really giving something to the insurance industry, where fraud is the biggest problem in the insurance industry. That fraud that takes place makes all of us pay more for our insurance every day. So the people who claim when they shouldn't claim, they're not your friends at the dinner party. Oh, I managed to get all my carpets and curtains replaced because there was a little bit of water in the house. They're not your friends. They're fraudulent. And the Act provides that the insurer will not be liable to pay any part of a fraudulent claim, can recover any money paid prior to the discovery of the fraud, and can by notice terminate the contract from the date of the fraud. It's gone. It's a bit like the breach of warranty, but you can't bring it back. It's gone. You cannot get another claim on that insurance, and you'll keep the premium as the insurer. So this is a fairly draconian resolution of this, but fraud has become a problem, and I congratulate the Commission for being firm about this, because I don't want to pay any more insurance premium for my car or my house. Under group insurance, like in health, I should say, innocent beneficiaries are not impacted. They can still get their claims paid out. So what is actually happening out there in the market in response to this? I said for consumer, it's already there. So, no change. The commercial, lots will probably contract out. Although, I was speaking to a friend in the market who says some of the bigger companies are already going along with it, using it as a marketing tool. We won't contract out. We will be subject to the new regime. If we don't pay claims on time, we'll pay damages. Look how good we are, we'll pay our claims straight away. So that's interesting. They're using it as a marketing tool to look good in the market. So we had a Marine Insurance Act of over 100 years ago. We had Lord Mansfield in Carter against Burme 250 years ago, bringing certainty of barema fides. The Marine Insurance Act was then litigated from 1906 onwards on the uncertain parts, and that litigation had really died out, or arbitration, because everything had been sorted out. That's what's wonderful about old acts. The lawyers can't find anything more to argue about. It's all been sorted out. Well, now that certainty's gone. In England, in the United Kingdom, we now have feeding mania for lawyers, academics, and judges. It's going to take a long time to sort out what all these new phrases, reasonable, fair presentations, wonderful phrases when you think of them. And I'm just so sorry I'm not still in private practice. It would have been great. Business people, however, are not so happy, because business likes certainty, especially in the insurance world. And now, of course, they're facing a lot of uncertainty, which will mean it's difficult for them. There'll be adjustments of premiums, and normally they'll adjust upwards in excess to cover themselves. So perhaps we will be the losers. Who knows? But the lawyers will be the winners. Anyway, I hope I've given you some idea of the revolution that's happened in the very old insurance law that has been established in London, the Lloyd's market, the company market, for so many years. Thank you.
Muchas gracias, Colin. Thank you very much for such an interesting presentation. Ahora quiero dar lugar, por favor, a Jorge Velarde como nuestro primer panelista, y luego vamos a dar lugar a Alonso Núñez del Prado para un comentario. Cada uno tiene 3 minutos. Por favor, ceñirse al tiempo. Gracias.
Thank you, Colin, for your interesting presentation. My question would be on the contract out.
You're speaking English, thank
Should
you.
we? Oh, sorry. ¿Cómo va a ser esto?
If you want to speak English, thank you. I wondered why I couldn't understand.
Tenemos traductor. ¿Quieres hablar en inglés? Aquí tienes que traducir.
Voy a hacer una pregunta, mejor le hago la pregunta en inglés, ¿no?
Okay.
Sí.
Thank you.
You say that it will be a marketing tool. So, but we don't know how will it actually develop, right? If the contract out prevails, what will be the actual material change with the previous law?
Not very much. Your fraud one is good, that'll still be there, but you can contract out of most of it. As I've said, however, there are already companies who saying we're not going to contract out. We will give you the benefit of these reforms, changes, which are believed to be in the interest of the insureds or the reinsureds, a marketing tool to get the business in. So once some of your big chaps have done that, others will probably have to follow. So it might be that the contracting out is not used very often, but we have to wait and see.
And that will apply to the reinsurance as well?
Yes.
Do you think that the reinsurance market will
there's more
also
chance
be,
that there will be contracting out in reinsurance, because as I said, you're dealing with big boys and girls, and they might prefer to have the certainty of the old regime. Most reinsurers will, because it was always thought to favor the reinsured. But you're right. You are perfectly right. It might be in that area, reinsurance, that the contracting out has teeth.
And the impact will probably be, in reinsurance contract, will be much harder for the reinsured than in the underlying contract if it was subject to this law.
Yes.
Right?
It's always been said that if you are a reinsurer, you want to be subject to English law as it stood before, because it was a very strict regime, whereas the new regime shifts the balance. So the big reinsurers might try and keep that regime, and they're powerful.
And do you think that at the end of the day, the imbalance has already become more fair?
Well, it's already, as I say, I don't know.
It has been a very insurer-friendly market, right?
Yes. Well, it definitely has shifted if what I'm told that companies are already saying they won't contract out. So it's definitely shifted in favor of insureds, commercial insureds, because they're using it as, I'm a wonderful insurer, I won't contract out of these things that are now to make it better for you, more reasonable with the cover you've obtained.
Interesting, and probably what will happen is that there will be more work for English lawyers, right?
I cannot imagine there wouldn't be.
Muchas gracias, Jorge,
And for judges.
Muchas gracias, Jorge, por tus preguntas, and thank you very much, Colin, for your amazing answers. And now damos lugar a Alonso Núñez del Prado para que haga su comentario como panelista. Muchas gracias.
Bueno, voy a tratar de ser breve. Yo quiero aprovechar la exposición de COLIN para traer a colación nuestra nueva ley de contrato de seguros. De alguna manera, la legislación que regulaba el sistema peruano hasta antes de la ley de contrato de seguros vigente desde el 2013 era la vigente en Inglaterra hasta antes de sus cambios recientes. Nosotros en la comisión que redactó el borrador del proyecto de ley, vimos que evidentemente se venía un cambio porque toda la legislación continental europea era una legislación que pretendía preservar el contrato. O sea, a diferencia de la legislación inglesa que permitía la nulidad del contrato, es decir, desde su inicio, nulo, inexistente, lo que había optado, digamos, la ley continental europea es por preservar el contrato, por mantenerlo y eventualmente sancionar a quien no había dado la información completa con pagos proporcionales. Además, en nuestro caso contaba que nosotros somos más bien herederos de la legislación continental europea. O sea, nosotros no seguimos el common law inglés, no seguimos la ley anglosajona. Así es que eso nos llevó a hacer los cambios que han suscitado tantas protestas en los aseguradores peruanos, pero que evidentemente obedecen a cómo vienen los vientos. O sea, tan fuerte vienen los vientos que los propios ingleses, como nos acaba de contar COLIN, han cambiado. O sea, de alguna manera nos hemos adelantado en unos meses, ¿no? En consecuencia, es cierto que las cosas vienen soplando en otro sentido. Es evidente que hoy día tiene mucho más importancia el asegurado de que la tenía antes, y eso ha llevado a que en la legislación peruana y poco después en la inglesa se realizaran los cambios que hemos visto, que llevan a una preservación del contrato que yo sí, con la cual yo sí simpatizo, ¿no? Gracias.
Muchas gracias. Quiero agradecer a cada uno de nuestros ponentes. I want to thank you.